Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business. Beth Owens, thanks so much for joining me today.
Thank you, John. Happy to be here.
So, Beth, it comes up frequently when we're talking about who should be in charge when somebody is gone. Well, do we want an individual? Do we trust our family members to be trustee and executor, or should we pay somebody like you to come in and take our hard-earned money instead of giving it to our beneficiaries? Beth, why on earth would we ever want a professional trustee?
So I tell people a lot of times it's just easier. Cost-wise, it's not as expensive as you actually would think the big bad bank would be. At the end of the day, where our costs increase, usually attorneys like you, sorry, John, yours decrease because
Right.
we're not picking up the phone and calling you like an individual trustee asking questions. We've done it a few decades, so we just keep on moving. So I usually look at the two things that I would actually, whenever determining whether I need an individual trustee or corporate trustee. So if you have sticky assets or sticky families. So if you're on a second marriage and you've got his kids, her kids, that's an ideal situation for a corporate trustee. But everybody gets along right now. Well, no, everybody doesn't get along after you're gone. They're putting on a very good show for you, but you would be shocked what happens when you're gone or when you can't manage your affairs anymore. And the
Right.
same thing with sticky assets. You think that they're all simple and hunky-dory, but your children may think otherwise, and they may not want to keep the family limited partnership up and running, and that was your intention all along. So
Right. Yeah. Just thinking through the amount of real and perceived slights that will come out, and it's time to finally settle scores because mom or dad aren't here to hold that dam back, and it is just all firing once
it
mom and dad are gone.
it's shocking too how that sibling rivalry that you've had as a child just blows up once mom and dad can no longer handle their own affairs or mom and dad aren't around anymore for everybody to put on a good show. It doesn't go away. The sibling rivalry does not go away. It just morphs into something expensive.
Right. So I mean, yeah, but just thinking about it, the family side, if the family's going to be a problem, you probably already know that already. Like if you're hearing this from your clients, just recognizing if they don't get along now, they're not going to get along certainly once you're gone.
Correct.
And so that's the reason. Again, the reason to pay for this is you're putting one person in charge, and almost certainly by putting that one person in charge, you're tipping the scale.
Mm-hmm. Mm-hmm. And if you put a corporate trustee in place, you have that neutral third party that doesn't have a sibling rivalry. We've got no emotions in this game. We've got the document that you spent your hard-earned dollars to draft with John, and you want to make sure that they follow it without being interfered by their emotions. And a neutral third party like a corporate trustee, that's what we do. And it takes the emotions out of it. And I can't tell you how many times I've had a brother or sister resign as the individual trustee. We step in, we take over, and they're shocked with how well behaved their sibling is with us. And I said, well, there's a big difference between me telling them how to spend their money or me telling them no than you telling them no. I mean, you're their sibling, that you're the one that they were trying to beat the basketball scores with. You were the one that had the better art project than they did. I'm nobody. I'm the banker. I'm the attorney. And that's all they see me as. And it's usually a breath of fresh air for a lot of families.
Right, because it's taking that kind of in the pressure out of the equation for everyone. But it's also, again, the fees that are going there are fees that aren't being spent on other attorney fees. Not only, potentially mine, but also the litigators. The rule of thumb I've learned from our litigator friends is, well, about 10% of the assets are going to disappear to a litigator or litigators if this really does blow up. And sure, there will be some that are far more than 10%, some that are far less, but that's a good number that I found that really focuses the mind for my
And
clients.
the smaller your estate, that higher the percentage. So
Right. And do you really want to spend this, even if it's $50,000 gift, obviously there's not much we're going to be able to do about it. People are just going to go sideways. But if it's a $2 million estate, that's a good chunk that is not going to your family.
that's exactly right. And if you're looking at a $2 million estate, depending on whether or not we pull the investments in-house or we continue to work with your advisor, you're looking at basically between $4,000 and a $10,000 increase annually for us to do the job versus an individual trustee. So, because if we pull the assets in-house, we do the investment management. Our fee for investment management is just 20 basis points less than what we charge as a trustee. So on a $2 million estate, that's literally $4,000 a year for us to do the heavy lifting and us to argue with the kids and try to set them up on a budget and try to make sure the bills are paid and so on. And it's really, and I'm sure most people would probably spend quadruple that on an attorney to argue with their sibling. So, or argue with even not their sibling. I've got a lot of uncles that are taking care of their nephews, and it's not a fun place to be when you start really crunching the numbers. Doesn't sound like a bad idea.
Right. And just you're paying for somebody else to do the job, even if you could do it yourself.
That's it. That's it.
Yeah. So, I mean, you mentioned sticky assets as well. What sort of things, will corporate trustees, let's start with, what will they take that otherwise aren't a great fit for individual trustees?
So, depending upon your corporate trustee, not all corporate trustees like real estate. That's kind of a tricky situation. But you usually will find some of the smaller banks will be happy to take real estate as long as it doesn't have the EPA issues, the environmental issues. So we won't take a nail salon, I won't take a mechanic shop, and I won't take a tire shop or a gas station. So if you've got any of those EPA issues involved, you probably won't get a corporate trustee involved because that kind of stuff scares the heck out of us. And it's usually expensive because we've got to do all the environmental surveys that typically an individual trustee wouldn't do. But the EPA will come after us if we don't do it right. And so that's kind of one sticky. Another opposite end of the sticky assets is kind of the simple assets. So you've got a family limited partnership. The trust assets consist of 90% of that family limited partnership. And that family limited partnership is, say, a small valve business. That's probably something you may want a corporate trustee on if you're worried about a conflict of interest with the general partner. But it may not be, because that may be a situation where a corporate trustee isn't going to want to continue to hold that partnership interest because it's not income producing and it's not in the best interest of the beneficiaries to hold that interest in the long run. And so that kind of, I've had the conversation recently with a gentleman who has a very valuable partnership in small business, and the majority of his trust is in that business. And I had to tell him, I said, here's the deal with, if you die tomorrow, that business isn't going to be worth what it is right now. And we have to answer to the beneficiaries We want to know that we are investing those trust assets as a prudent investor. And if I'm holding a business that's declining in value year after year after year, the corporate trustee isn't going to be able to stay on board with that. So anyways, so you've got your two ends of the spectrum there.
Right. And I mean, thinking about those business issues, it brings up, well, not only are you potentially holding on to an asset that's not as valuable, but you're potentially also concentrated in that business as an overall portion of the trust estate.
And the concentration issues I try to nip in the bud on the front end. I know I've had many conversations that, yes, I realize that the trust agreement allows me to hold a concentration, but as a corporate trustee, we really want you to force us to. So rather than using the may hold the concentration, a little tweaking in the trust document to say shall hold the concentration makes our life a lot easier down the line. The corporate trustee not only has to answer to the beneficiaries and to the court, we also have to answer to our federal regulators. And so if we don't have a good explanation for our federal regulators, they'll make us resign. Or they'll make us diversify. Neither one of which is a good situation for the client. So if we can add some language, and if the language isn't in there when a corporate trustee steps in, I love to go back to court and modify, especially with your Texas trust. I will go back to court and modify it to add concentration language. As long as all the beneficiaries agree, I will do it in a heartbeat. Modification like that is very simple in Texas. It's very cost effective. A lot of times it doesn't even require a hearing. And so that's a workaround if you're in the situation that you need to force your corporate trustee to hold the concentration. So
what are some other things that beyond the highly concentrated asset, something that's taking up disproportionate space in the estate, what else might cause problems for you or someone else as a corporate trustee getting in and settling messes?
Lack of information. So when you're thinking about a corporate trustee to take over for when you can't do it anymore or when you pass on, it's really nice if we have information ahead of time. So I request a copy of those documents, a copy of the executed documents, a 15, 20-minute conversation to tell me about all the skeletons that are in the closet. Oh, you're going to have an issue with this person. Why am I going to have an issue with this person? Oh, well, because of this, this, and this. And then I can take those notes and I can scan those and save them to the file because I'll create a file for you. And most corporate trustees do that and they save it. And we have a system that holds all of our wills along with the notes and any other information. A balance sheet is helpful, where all your assets are. So whenever we do have to step in, I'm not waiting on the mail to get forwarded to me in order for me to figure out where your assets are. So any information you can give to us on the front end is always helpful.
Right. Just forewarned, it's forearmed.
Yep. So I know I've had several conversations with your clients, John, and I have about 8 pages of notes on one of them that I have saved to the file because I'm like, ooh, star, we're going to need to know this 20 years from now.
20 years from now.
And it'll be there. I mean, because we save everything. We have all of our documents saved in 3 different spots. So if one burns up in a fire, we've got it saved over here. And then, so whenever that call is made, we typically go straight to our spreadsheet into our database to see, do we already have their documents? Do we have any information on them? And if it's a yes, it sure does make life a lot easier.
Right. Well, as we start to close down this episode, Beth, is there anything else advisors should be thinking about when they hear their clients, either have family squabbles that may erupt after they're gone, or if they're even considering corporate trustees?
When it comes to advisors, they need to keep in mind that a corporate trustee isn't out to steal the business from them. You can add language to the document. Texas has a great directed trust statute that we can add to the document. And then it'll let us be corporate trustee and it'll let them be the investment advisor. So I really strive to tell advisor, try to to encourage them, don't rule me out because you're worried I'm going to take your business. The trust document doesn't allow me to do that. So I'm going to sit here and do my job and let you do your job. And in the long run, it'll be better for the client and their family.
Perfect. Well, Beth, for anybody who wants to follow up with you, where can they find you?
So the best way to get a hold of me usually is by email. And I'm sure you're going to add that to the website.
We will.
And usually give me a few days to get back to you. So I do all sorts of fun stuff in my spare time, like clean out people's houses and after they passed on. And so that's what I've been doing all week. This week was I spent the last 3 days and cleaning out a house, the glamorous work of the trust business.
Never stops.
So, but the email is typically the best way. And that way, if I'm out of the office, somebody can come in and grab the email and respond back to you, hopefully within 3 to 5 business days.
Excellent. Well, Beth, thanks so much for joining us.
Thank you for having me, John. I appreciate it.
Thanks so much for listening. You can find more episodes, videos, and links to more helpful content at nounfinishedbusiness.com. If you have any questions, feedback, or ideas for topics, please reach out via social media or email John at john@stromeyerlaw.com. And of course, if you or your clients need help from John with an estate planning, probate, trust, or cross-border tax issue, you can book time directly with John at askjohnaquestion.com.